Hi, welcome to Module 4, where we're starting to really get into the nitty-gritty of design thinking and what it has to offer for us as administrative law practitioners. Now, this is an area which is, I guess, the most innovative part of our course, and it's something which is not typically covered in administrative law courses. And that's because at CQ we're really looking towards future legal careers, and we're looking for the sorts of careers that lawyers are going to be employed in coming up in the future by the time you graduate, not necessarily the same sort of careers that were in the past. So very much in the past, admin law was a very reactive discipline. It was very much waiting for something to have happened and then to wait for a challenge, a legal challenge to occur to a decision. And that's either you were someone who was representing the person who was making the challenge, or you were working for the organisation that was facing the challenge to the decision making. What we find now is that we need to think more about systems and designing systems where decisions are made properly in the first place. That we don't need the challenge system. It's there as a backup when things go wrong, but we want to make our systems better by design. We want to make them a system where we don't waste time and energy facing appeals that we're necessarily going to lose. And these ideas apply, of course, primarily in this subject to the field of public law, but they're just as appropriate to private law and private organisations and the design of any bureaucracies. And part of this, I think, is also about the importance, it's about the importance of system thinking and understanding how systems work. So admin law, I think, is one of the areas of law where we see social complexity impact on law the most significantly. When you go back to the very early days of admin law, it was really a tool of the king. And in fact, we still talk about royal prerogative writs because they were the prerogative of the king. And they came at a time when the king could no longer exercise direct power over their subordinates. Back before administrative law was created, the king had such a small organisation, maybe a few generals, a few palace servants, that if there was some project or some system that was being administered and they didn't like it, they just brought the person in, brought the torturer in, and found out, personally what was going wrong. We then end up with the rise of the cities, people moving into cities. You had much more complicated social systems and much more complicated bureaucracy, where suddenly the king didn't necessarily know all those functionaries and flunkies who were administering all those systems. And the courts then had a role in supervising and overseeing those systems. So the very increase in complexity in society and the increase in complexity in those systems and the degree of automation in those systems and the removedness of the ruler from those systems all meant that we needed to develop a system of law which provided access. And these were those early writs, and we'll talk about those next week. Well, coming up soon when we talk about prerogative writs. But the very origins of admin law wasn't a tool of the people against government. It was a tool of the king against the king's own government to say, let's find out what's going on and why people aren't doing their jobs and fix that up. Of course, today we stand as citizens in the place of the king. We are sovereign now as citizens, and we take up that kind of role. So it's always been about complexity. It's always been about changing social dynamics and increasingly complex systems. And one of the themes that we talk about in this course, we're not looking at directly here, but of course it's relevant, is the rise of technology in administration, where more and more we are drawing on technologies of surveillance, of measuring, and even decision making, where technologies are making decisions for us that would ordinarily be made by a person. So you might end up with a situation where a red light camera is not only recording information about whether or not you've gone through a red light, but it's kind of making the decision. It's sending out an automated fine. The system itself has become automated, and that's providing new challenges for admin law. So going back to systems thinking, it's very important to think about these in terms of systems and how those systems operate. And I guess we can make assumptions about how well government operates and what government does, but in reality, a lot of what government does is quite ad hoc. So when we look at the design, the videos on design thinking are much more interesting and better design than anything I could do. So have a look at those before you go too much further. But a lot of the process that goes into design thinking, particularly in understanding, being proactive and looking at a system, understanding, planning, looking at the client base, looking at what their needs are, look at how the systems work, iterating, developing new models, trying them out, prototyping, developing. None of that stuff actually happens now. Generally, when you have a regulatory system, it's either one that we've had for a long time that we maybe make a few changes along the way or introduce some new technologies to, or it's a new system where we just kind of throw something together. By the time something has gone through the process of becoming law and regulations have been enacted under that law, it's generally too late to make very much change to the way in which a system works. And generally a lot of what goes on is sort of at the 11th hour, where some government bureaucracy is told, oh, by the way, this is a new law and you have to enforce it. And we've seen some spectacular failures to do that, most notably being, from my particular research interest, the internet censorship laws that came in at the start of the turn of the millennium, which had high ambitions to regulate what people could see and access via the internet. And at the end of the day, have done absolutely nothing. They're absolutely ineffectual. And the reason for this is there was no process, there was no procedure by which we actually looked at developing a system, prototyping it and seeing if it worked. And there are reasons for that, which I'm not going to talk about here. It would take it would take more than one video to talk about all of that. But the point I'm making is that we might assume that there's so much money in government, that they have so many resources, that they're actually better at this stuff than they are. And the fact of the matter is, we are going into sort of 21st century regulatory systems with very much a 20th century or earlier view as to how we do things. And one of the ambitions of this subject and introducing these ideas is to bring some interdisciplinary thought into the field so that you folks, as the next generation of lawyers, can actually start talking in some of that language around design, and actually think about how these things apply. And I was talking to someone from the AAT recently about this, and they're quite excited by this concept. I've been quite pleased with how people in the field have said, yeah, we need more of this, we're really interested in this. And what they told me was there's more prototyping that goes on their websites and their web systems than ever goes on the actual procedures, because generally the procedures are just delivered a fait accompli, and you have to work with them until you get to such a point where there are enough complaints or enough problems with the system that you can try and feed the information back up and try and get a new system of procedures involved. And I thought that was very interesting, was that we think about things like websites and we think about users for that and accessibility and all those issues, but they end up sort of segregated off to the side, and they're not seen as part of the administrative system itself. But as our administrative systems become more and more technological, and we end up having computers being more and more involved in the decision making and the record keeping, those websites are actually part of the system as much as the person who sits in an office who has the big stamp that says rejected or accepted and stamps those things. So this is a very interesting field going forward. I know some people will react to this and say, and will grumble about it and say, this isn't law, this is not cases or whatever, but it is, and this is the way law is changing. This is the way law is going, and the 21st century legal skills involve you taking on several different roles and several different hats. So I think even if you never end up working in public law, this will hopefully get you thinking about some of those issues around regulatory systems and design of systems that will have you starting to think about what it is to be a lawyer in a world which is very much mediated by technologies.